Dushyant Dave, why don't you start first? Because here you've got a situation where you've got a new Chief Justice who's come in, UU Lalit, and in the last 10 days, suddenly we are seeing a number of these tricky constitutional questions now finally making their way to constitution benches of the Supreme Court. The Places of Worship Act likely to be also heard. You've got the Citizenship Amendment Act finally being heard. Hijab cases being heard. Are these cases where the Supreme Court can really assert its independence in your view?
Well, Supreme Court is ultimately the final constitutional court and is the ultimate arbiter of all these disputes, whether they have religious connotations or they don't have. The Supreme Court must really go into it and decide, because ultimately people will accept the verdict of the Supreme Court as final rather than, the political decisions. I think Chief Justice Lalit is doing a good job in that regard, trying to fix matters before the Constitution bench. And, you must realize that most of these constitutional matters which are referred to the constitutional benches are on account of the, extraordinary importance of interpretation of the Constitution, or because they have been referred on account of conflict of various, benches of the lower strength, 3 judges benches, which have referred them to larger benches on account of various, constitutional and legal issues. So I think for a long time, these petitions have been pending in the Supreme Court. And it's nice that Chief Justice Lalit is taking them with alacrity and trying in, although he has a short tenure of 74 days, but he's definitely making a remarkable, I would say, progress in fixing these matters for hearing. And I think it's right that these matters should be fixed. They should be heard, and the Supreme Court should speak. Ultimately, that will be the final word, and it will put quietus to many issues, including, for example, as you said, on CAA, which is really, troubling a sizable section of the society, because a lot of people feel that they might be thrown out of this country. So I think these constitutional issues need to be decided, and I would say that I compliment Chief Justice Lalit for having taken the initiative.
Let me though come to the specific case for a moment to you, Faizan Mustafa, that has triggered off in a way the top story today. The fact is that in Varanasi, a lower court has said that a title suit or a suit allowing for worshipping rights is maintainable. Where does that fit in with the tricky constitutional question of the Places of Worship Act, which said that there would be status quo on all places of worship as of August 15, 1947. Now, can the court, which is good, the Supreme Court will be faced by this sooner or later. Today, it's only in a lower court, as we saw with Ayodhya. Eventually, these matters will reach the apex court. Is the court in a position, you believe, to pronounce on these tricky religious issues?
Rajdeep, I think there was not much of an option, because, this matter reached the Supreme Court, and it was the Supreme Court which said, let the district judge of Varanasi decide the maintainability. Now, today's matter was whether there should be, whether this case should be heard on merits. So all the objections which were made against the maintainability of this suit have been rejected. And what the district judge of the Varanasi has said, that the 1991 Act talks of prohibition of conversion of place of worship from one religious character to another religious character. These 5 petitioners, he is saying, have not claimed ownership. They are not saying convert this temple into a mosque. They are merely asking for their right of worship, which he says is the right to, a civil right which a civil court can enforce. Similarly, he is saying that what is prohibited is the conversion, but ascertainment of religious character of a place of worship is not prohibited. And Rajdeep, you will recall that Justice Chandrachud of the Supreme Court, when this matter had come few months back in the Supreme Court, had made similar observation that ascertainment is not prohibited.
But this could open up the floodgates, isn't it, Professor Mustafa? Today it is Varanasi. Today there are numerous religious disputes where different communities challenge the religious character of a place. and then you will come to the Supreme Court, and the Supreme Court now will be bound by, in a way, what they've decided in the Gyanvapi case, that you allow issues to be settled at the lower court, or allow the issue of the maintainability at least at the lower court over whether the right to worship exists or not.
No, that's right, Rajdeep. It is going to open the floodgate of litigation, because if ascertainment is permitted, that means 1991 Act would lose its efficacy. But if you go to this 26-page order of the Varanasi court, he is also saying that there is an act, Kashi Vishwanath Temple Act of 1983, which has already in a way declared it to be a temple, and therefore 91 Act is not attractive. Similarly, he is saying that this character of the property as waqf property is a dispute, and merely if in the revenue record some property is mentioned as a waqf property, it doesn't make it a waqf property, it doesn't decide the title. So it's an interesting order, but you are right that many similar cases are now going to come up, and the original legislative intent of 91 Act to freeze the character of religious places on August 15, 1947 is going to be really compromised.